that recording now. All right, well, why don't we start off, and they can join late if they're joining. So
Sure,
just a little bit more about our firm. We have three organizations as part of our conglomerate. The law firm that you've learned of is an Notice to Owner, which is a company that we started as an affiliate to handle on a very cost-effective basis those notice to owners that we briefly discussed and that you'll learn more about today, because they're very persnickety and there are penalties for not doing it right or not doing it at all. And then the Zinsel Law Foundation, which is our charity. Sort of the why we do everything we do is our ethos, which I think was in the brochure that we sent you. But we are all deeply patriotic Americans. We are unapologetic about it. And if people don't like that, they can go hire a different law firm. We wear it on our sleeves, including editorials to the bar, tackling disputes with judges who may disagree with our philosophy, and opposing counsel, and all of that. And what you might appreciate sort of is the how we do what we do, which we don't sort of publicize, but we have a deeply shared honor code, kind of old school. In fact, appropriate to Texas, the code of the West. We follow that to a T. We talk about it. We weave it into our daily activities. And as a firm, because we specialize in only representing companies in the construction and development industry, we handle, yes, the substantive constructional issues like we're going to talk about today and more, but also bankruptcy, lending issues, real estate, and so many more of the things that construction companies deal with day to day. So without further ado, let's get into the meat and potatoes of it. I'm going to try to cover at a high level today a lot of different things to give you a broad overview. So really it divides into three sections: liens and collection, construction defects, and legislation. So what's the NTO? What are the requirements? What are the exceptions? And what are the best practices? Lien rights. Who has them? How do you keep them? How do you not lose them? Construction defect claims, just a little review about the unique Chapter 558 pre-suit process we have here, how to deal with that. The statute of limitations and repose, which is extraordinarily lengthy in Florida, and a little bit about that. And then pending legislation related to these topics. So we can chat about that a little bit. So the NTO. Essentially, the general rule is that if you do not have a contract with the property owner, then you must serve a notice to owner. You have to serve the notice to owner within 15 days of final furnishing of within 45 days of first furnishing of labor, services, or materials, or before you first furnish labor, services, or materials. The critical issue here is a company like Bayonet, for example, that does work with a lot of large-scale developers, right? They all operate under sort of the same moniker, whatever it is, and they're not the owners. As I'm sure you're well aware, big companies bifurcate their holdings from their liabilities, so the actual property owner is different from the contracting party, is different from the developer party, so you've got to serve notice to owner even when working for those developers. There is a tricky exception to the notice to owner requirement, which is called common identity. Essentially means that if the principal owners of the various entities, meaning the contractor and the property owner, are the same, then you don't have to serve notice to owner. But that's sort of a lawyer trick, right? Is contractors should never rely on that. In an abundance of caution, always serve notice to owner. It's not a claim. And as I said, you can serve it any time before first furnishing, but no later than 45 days after first furnishing. So there's an exception to some of these rules, right? First furnishing is a term of art. It means not your first day on the job. It means the first day you start, you start work in connection with that project. And there's a unique rule for specially fabricated materials, essentially materials that cannot, except with a great deal of difficulty, be used on a different project. And for those, the notice to owner deadline starts to accrue the moment you start specially fabricating those materials, even if you have never yet delivered them to the job site or set foot on the job site. So the best practice here, and one that we had recommended to Bayonet, for example, years ago, is it's not practical to serve a notice to owner for every single project, either because you don't have the staff to do that volume, or if you're using a service like our notice to owner organization, you just don't want to spend the money for every single project. So set a dollar threshold of the ones you're always going to serve, and then don't wait until you need to do it. When you get the contract, the purchase order, the verbal phone call that says, hey, I need this, that's the time at which you should do it. And just to give you a quick look, this was a policy at Bruce's request back in 2018 that we developed with some background for their administrative collection professionals on notice to owner deadlines, and then ultimately at the end, collection policy. Portions of this I know were implemented. I don't know how much of it was or is still in place. And I do know they are not using our notice to owner service. So it's old, but just to give you a sense, that's a great thing to develop. And by the way, interrupt with questions. I'm trying to go through it quickly since we've only got an hour. Okay, lien rights, who has them? Well, first of all, if you don't serve a notice to owner timely and you don't serve it correctly, and you were required to, you have no lien rights, period, end of sentence. So it's really critical that notice to owner be timely and properly served. By the way, it has to be served. Yes.
If you don't have that notice to owner served, and here you are, the job is over, they haven't paid you, do you just have to sue them immediately?
You can sue for breach of contract up to the statute of limitations in Florida. If it's a written contract, it's 5 years. Or if you don't have a written contract, it's verbal, 4 years, or quasi-contract claims, 4 years. But yes, you would lose completely your lien right. Lien law in Florida is very, very tricky. We're going to go over some other ways you lose it, but not everybody has lien rights, even assuming you do things correctly. So the first question is, what tier are you? If you are in direct contractual privity, you have a lien right, and you don't have to serve notice to owner. If that is with the property owner. If you are not in direct contractual privity, only subcontractors down to the second tier have lien rights. Third tier subcontractors do not have lien rights at all. Who can prepare the lien? Under Florida law, the contractor or the contractor's attorney can prepare the lien, nobody else. It's a felony for anyone else to prepare a construction lien in Florida. Be careful with affiliates. So if IES Residential, for example, is preparing the liens for a Bayonet, that may actually be a felony. So you have to be mindful of that. Once you have a lien, what priority does it have? So in Florida, timely recorded claims of lien, and we'll talk about timeliness in a moment, relate back in time and priority to the date an unexpired notice of commencement was recorded. So the property owner is supposed to record a notice of commencement before actually commencing construction. When you apply for a building permit, the building permit authority, city, county, is required by law to give the owner, generally contractor, a notice of commencement form to complete. I say unexpired because a notice of commencement only lasts for 1 year in Florida unless it says otherwise on its face. And you have to be careful. There may be multiple notices of commencement, and each is sort of its own string, if you will, depending on who actually hired whom under which notice of commencement. So relation back is absolutely key. If you don't have relation back, then the lien is just sort of like a mortgage or any other lien, where it takes effect as of the date and time that it's actually recorded. So the deadline to serve the deadline to record a claim of lien is 90 days from final furnishing, and it has to be served via one of the acceptable service methods within 15 days of recording or before recording. So serve it before or serve it on the day recorded, just to be safe. Final furnishing also is a term of art. Final furnishing does not start counting from punch list or warranty work. Stated differently, if you're calculating your 90 days based on the last date you were there, you have to be careful because it was likely started earlier. So when we're being asked, for example, to record a lien, we start asking immediately who was on site, what were they doing, on what dates, how many labor hours did it take, because we have to gather that information to make sure we calculate and calendar the lien deadline accordingly. There's a special exception to the 90 days, and it's basically when a project ceases for a period of time and the notice of commencement recorded by that original contractor is terminated, and the property owner decides to recommence construction either with that prime contractor or with a new prime contractor. When that happens, the deadline to record a claim of lien is no longer 90 days. It's actually 30 days from the affidavit of intention to recommence. And that is from the recording of the affidavit, not from service of it. And this can also affect priority as well, even if you comply with that 30-day mechanism.
Did they have a duty to send us a copy of that notice so that we know something's happened?
That's correct. So it's recorded and it must be served via the usual service methods, which are delivery, certified mail, or common carrier like FedEx, et cetera, with tracking. Claim of lien form, right? So it's a form. It is quite literally in the statute. It's got blank lines in it, but it isn't plug and play in that sense. It's deceptive. The claim of lien form itself is easy, but what goes in it is not. So, for example, to be included in a lien sum, the thing that you're leaning for had to be required by the contract. In other words, volunteering extra work, or if it's ambiguous, whether it was actually expressly required by the contract or not, impacts whether you actually have the right to include it in a lien, which means change orders may or may not be properly includable in the lien. And oftentimes that's what you're wanting to lien for, or at least a substantial portion are proposed change orders, extra costs, et cetera. So again, each is very fact specific and has to be appropriately analyzed for the potential risk, because the risk is that it could be deemed a fraudulent lien. A fraudulent lien sounds terrible. It's not a crime, but essentially there's three ways a lien can be deemed fraudulent. It's a willful exaggeration. Only slimy contractors end up in that boat. It willfully included work that was never done, same thing. The third one is the tricky one though, and that's where contractors with best of intentions get caught, and it's that they compiled the lien with willful and gross negligence. Simple mistakes don't transform an otherwise valid lien into a fraudulent lien, but including things that are most definitely not includable does. So you can't include interest, for example, even if it's allowed by your contract. You can't include attorney's fees, even though those are recoverable under the lien law in a foreclosure action. But change orders is a widely disputed item, and in pretty much every action to foreclose a lien where it includes a disputed change order, the property owner will countersue for fraudulent lien. Why? Because if the court finds the lien is fraudulent, it is a complete defense to the entire lien, wipes it out completely. The owner is entitled to attorney's fees and to damages incurred as in connection with that fraudulent lien. So lien rights, you got a lien, you record the lien timely, you serve it timely and all of that. How long does it last? A year.
Oh, I've
After,
heard, I had a question for you, Justin. So what do
yes,
you do when you've got $100,000 in retainage and another $50,000 in change orders? Do you not lien the entire 150,000?
great question. So I'm gonna go back to the prior screen here. A couple of things. One, the lien amount is different than the contract amount. So in other words, under a construction draw at issue, you may only be entitled to certain sum less retainage or a portion. The lien law is not controlled by the contract or the contract draw schedule. So most often your lien will be in excess of the contractual draw amount you're entitled to at that very point, because it's based upon the value of improvements to the real property. So you can include retainage, even if it's not yet due under the contract. And if it's a dispute, if it's an agreed change order, then it's contractual and you're entitled to lien it. If it's a disputed change order, you may be entitled to lien it, but we're going to want to gather the facts, the information, what evidence we have that suggests that the owner is likely liable. In other words, you're likely entitled to it under your contract, whether or not it's a contract with the owner or not. And part of the reason I skipped this before I went to the next slide is the important defense. In Florida, it is a complete defense to a fraudulent lien assertion if the contractor had an attorney prepare the lien. Complete defense, provided the attorney doesn't just rubber stamp, but rather does due diligence and gathers documents, information, talks to the client, and makes a determination of what's properly includable. So depending on risk tolerance, we'll include all sorts of things in a lien as long as the clients go in with eyes wide open. So lien duration a year. After a year, it expires automatically unless you've timely commenced a foreclosure action. But you have to look out for some things. These are the tricks owners use to shorten the duration. So one is a notice of contest of lien, which shortens the duration from 1 year to 60 days. I'm going to show you real quick. That's an example of what they look like. You get one of those, alert counsel immediately. Another is what's called a show cause action. This one will definitely raise your eyebrows because it looks like a lawsuit. It in fact is, but it's a unique creature where the owner files it and the court issues an order saying, contractor, you need to show cause within 20 days why I shouldn't discharge this lien. So basically the way you show cause is by commencing a foreclosure action, essentially. So, but that shortens 1 year to 20 days. Okay, so you've done all of that stuff. You can still lose your lien rights other ways. We already talked about notice to owner briefly, or notice to owner defects. So as an example, if it's served incorrectly, meaning not via the correct service methods, you have no lien right. If you serve it untimely, you have no lien rights. If you serve it on the wrong party, you have no lien rights. So the lien law indicates that a notice to owner has to be served at minimum to the owner at the address indicated in the notice of commencement, not to their place of business that you know about, not to the service address listed in a contract that you see, not to an address indicated on the property appraisers or the tax collector's website. You also have to serve notice to owner on anyone who is listed in the notice of commencement that wishes to receive notice. Oftentimes a lender, if there's a construction lender, sometimes owner's counsel or others. If there is no notice of commencement, you have to serve it on the address for the owner listed in the application for the building permit, not even the address in the building permit. So there's some tricky stuff there. Another big way is a request for sworn statement of account. You get one of these, alert counsel right away, because there's 30 days to provide a proper sworn statement or the lien right is destroyed. And this is what one of those requests look like. It does have the 30-day language in it, but just to give you an example. The next item is what's called a request for contract by either the property owner or your customer if it's not the property owner. So with this, it could quite literally be a letter. It's nothing formal. It doesn't jump out as a legal instrument. It simply requests a copy of your contract with your customer. There's technically no deadline to respond. And technically, it doesn't automatically extinguish lien rights. However, if you fail to timely or reasonably timely respond, it gives the owner a damages claim against the contractor for failing to provide the requisite information, and that will certainly be offset against the lien right. The next one is what's called a request for a list of subcontractors and suppliers, if you have any. So you have a 10-day deadline to respond. Again, here, this is a letter. It's one sentence. It has no disclaimers or anything special on it that will alert you to the risk of not responding, which is why it's so risky. But basically what that feature does is if you fail to provide the list of subcontractors and suppliers that you are utilizing for that project, then it negates the lien right to the extent the owner was prejudiced by your failing to timely provide or provide at all that information. Okay, so let's say you've done all of that stuff correctly, and there's way more detail to it and a lot more exceptions than I'm going through today, but the lien law is extraordinarily complex in Florida, and the courts strictly construe it. So little mistakes can destroy your lien rights. So let's say you've done all of that stuff right. One of the things you have to be mindful of are some of these general collection protections that exist in Florida that keep you between the money you're trying to collect and and the debtor, and apply whether or not you've complied with Chapter 713 or contractual requirements. One of those is in Chapter 559 Florida statutes. So if you are doing work on residential property as a contractor, you have to think about the Florida Consumer Collection Practices Act. And when I say residential property, I don't mean that you are constructing, say, HVAC or electrical or plumbing on a piece of property that is presently owned by a commercial developer. What I'm talking about is your property that is owned by a human being. It is their home, so we're talking service work, and we're talking other construction improvements for a homeowner, where the benefit to the homeowner is primarily for household and consumer and family purposes. So many creditors are familiar with what we call the FDCPA, the Fair Debt Collection Practices Act. That is different than the FCCPA. So the FDCPA is applicable to debt collectors defined as someone other than the contractor attempting to collect the debt. So for example, if IES Residential was attempting to collect a debt for one of its subsidiaries, it would actually be regulated by the FDCPA, whereas the contractor itself would not be. The FDCPA is kind of what we call the thou shalt. So for example, this is the law that says when you attempt to collect a debt as a debt collector, you have to serve in writing what's called the mini Miranda, which is essentially a bunch of disclosures to the debtor about their rights. And then in every subsequent communications, you have to have certain other information. If the debtor requests verification of the debt, you have to stop collecting until you provide it, all that kind of stuff. The FCCPA is sort of the opposite end of the coin. It's the thou shall not statute. And so those are big differences. And under the FCCPA, the original creditor, i.e. the contractor, is deemed a debt collector. So the bayonets of the world, when they are attempting to collect a consumer debt, are subject to the FCCPA. And there's some tricky stuff in there that is not necessarily intuitive, that are gotchas used by plaintiff lawyers on a contingency fee basis. And they're nasty. They're nasty suits that where the plaintiffs seek class action status, and there's essentially a one-sided attorney's fee provision. So you end up writing big checks to settle things unless you want to write bigger checks to settle. So some of the things, just going to list them all at once, right, is these are some of the gotchas that are used. There are a lot more, but I didn't include sort of the slimy underbelly of debt collection. These are the ones I think are most relevant. So you can't disclose it to others. So be careful leaving a voicemail at someone's home or on their cellular phone about, you know, call me back concerning your past due account. That could be a violation if someone else hears it, like another family member. Communicating with the debtor's employer, same thing. Be careful of voicemail messages or passing messages through a receptionist or an assistant or something like that. Frequency of communication. You can't do anything that is deemed harassing to the debtor. And the standard under this law is the least sophisticated consumer, right? So imagine 2 calls a day or 1 call a day might be harassing. So you have to be mindful of those kinds of things. This is a biggie, claiming rights you don't have, right? So imagine if you're saying, hey, you know, look, we don't want to lien your property, but if you don't pay in X days, we're going to record a construction lien through our counsel. Well, if you haven't preserved your right to a lien and you threaten that, you just violated the FCCPA. So you have to be very careful. Likewise, if the claim, you're probably not doing this, but if the claim is time barred by the statute of limitations, you know, you don't want to be threatening. But the lien issue is a biggie. That's a common mistake. Or threatening to take an action you're not going to intend to take. So if you know you're not going to lien, or you know you're not going to send it to outside counsel to sue, don't you dare threaten it. You cannot make the bluffs on these kinds of collection matters. Publishing the debt, right? It prohibits deadbeat debtor lists, as they're called, which slimy collection agencies threaten to use. Put it on the internet. That's not what I'm talking about. I'm talking about, like, you send an envelope, right? It's got the windows on it for the recipient and so forth. Be careful what shows through. That can be a violation. And if you know the debtor is represented by an attorney, you can no longer communicate directly with the debtor. You have to communicate through the attorney unless the attorney has stopped communicating and hasn't responded in the last 30 days. Okay, what about commercial? So if it's a commercial debt, everything else, right? There's no restrictions, no similar restrictions, unless, again, an affiliate or a parent company is attempting to collect for a subsidiary or affiliate. In that case, the collector would have to register in Florida as essentially a collection agency. So that's something to be mindful of because that carries its own penalties. Okay, before we switch to defects, questions about anything we've chatted about so far? Good. Okay. All right, construction defects. So just briefly, some of the common claims, right? Breach of contract, simple. Privity of contracts required for that. Breach of an express warranty, same deal. You need privity. But here's some other interesting ones. Implied warranty. So we're talking implied warranty of merchantability. We're also talking, like, for condominiums, there are special implied statutory warranties, 3 years on mechanical and plumbing as well as roofing, 1 year on everything else. And that's a warranty by the party in privity and also all subcontractors downstream, regardless of tier. No privity is required for that. Negligence, no privity. Florida Building Code, no privity, but so any the current owners, subsequent owners could sue for implied warranties, negligence, or Florida Building Code. But the violation of Florida Building Code cause of action is limited to, thankfully, we got this changed 2 years ago, to actions where there is a substantial likelihood of a life safety injury. So it's got to be really material. Okay, so one of the big things in Florida is this Chapter 558 Florida statute. So I'm going to talk a little bit about it, and I'm going to tell you why it's the statute that everybody loves to hate. In fact, I'm going to be in our state capitol next month with utility contractors trade group lobbying for a bill, which we're going to talk about in a second, to change portions of this statute and some other things. We tinker with it every year. I'm in Tallahassee, the capital, every year. Our firm is very involved in these things, and it's just a terrible law. It doesn't work quite right, because it's a law with no significant teeth. So what does it do? Essentially, it's a pre-suit dispute resolution mechanism. Most contractors have seen a zillion of these things, especially if they're working in tract home developments or with condominiums. So the owner has to send this special statutory notice of construction defects to anyone it believes is responsible for one or more construction defects at the property. It has to be served 60 days before the owner can bring a lawsuit. And the owner is technically required to endeavor to serve that notice within 15 days of discovering the purported defect. It has to describe in particular detail the area of the defects. And believe it or not, you'd see these notices that says we have a plumbing defect at the property. It's like, well, it's a 3-story property. Where's the defect? They never actually had to point it out, and wouldn't, because it was never really about resolving the defect. It was about attorney's fees, right? So now they have to at least describe where it is. They have to describe it in detail. They have to actually inspect the property, which you go, duh. Well, no, they weren't doing that. They weren't doing that either. Basically, you had plaintiff's lawyers saying, well, it's an older building or it's a tract home. Surely there are defects, and just sending out notices alleging all kinds of defects that they never bothered to inspect for. Okay, so we're going to talk about statute of limitations and such in a minute, but basically the 558 process tolls or pauses the statute of limitations from running, but does not toll the statute of repose. We'll talk about the statute of repose in a moment. The contractor receiving the notice directly from the owner, so whether it's a subcontractor or the prime contractor, has 30 days to inspect the premises and the right to perform destructive testing as needed, with certain requirements being met. That contractor who initially receives the 558 notice has 10 days to send it downstream to anyone else who might be responsible for the alleged defects. And then the person downstream has 15 days to respond upstream, and all that gets rolled up into a proposal, if desired, by the contractors who initially received the 558 notice to resolve the defect. That resolution proposal has to be served within 45 days from the original 558 notice. And basically, you don't have to propose anything, you can deny it. You can propose to pay money to resolve it, or you can propose a certain fix to resolve it. There are no penalties for non-compliance with these mechanisms, other than a few, and they're hit and miss enforced. But if you're a contractor and the owner hasn't complied, you're sure as heck going to argue their failures. On paper, they sound really huge. So one of them is, if the owner fails to comply with the process, it's not entitled to admit into evidence at trial any evidence relating to the issue it failed to comply on. Well, that's huge. If you don't have evidence, you can't win a case. But it's got to go all the way to trial before that bar occurs, which means everybody's spending money and so forth. There are ways to try to get the court to, through limine motions, et cetera, dispose of a case far earlier than trial. But that's one of the penalties. Another is if the owner has failed to comply, you can ask the court to stay the case, to pause the case until full compliance is complete. And there may be two reasons for that. One is you actually earnestly as a contractor want the opportunity to inspect and propose a meaningful resolution to avoid litigation. Or oftentimes you have non-construction experts who are kicking off these claims, and they may be bumping up against a statute of limitations or a statute of repose, which aren't told, right? So them having to go back and send the 558 and wait 60 days may make their claim time barred, because it's as though the lawsuit was never filed to begin with. Or they may have already done all of the repairs or replacement before sending the 558, which deprives the contractor from the opportunity to inspect and propose a cure, which may be the death knell to the owner's claim if you set it up that way. Again, judges are hit and miss on it as far as what they will do, but those are some of the penalties. There are a few others, but each year we try to add more teeth to the law, and it's, you know, little by little we're getting pieces of it done. But one of the big issues you should know is that a lot of insurance carriers don't consider a 558 a loss or a claim, meaning they will not assign counsel, they will not pay for experts to investigate until a lawsuit is filed, which is a shame because you lose a meaningful opportunity potentially to resolve the claim. So you get a 558, you want to notify your regular counsel right away. Insurance can come in later as needed, but don't wait for that lawsuit, because you're already racking up costs and you're losing opportunities. Okay, let's see. Statute of limitations. So I mentioned it's long. It's 4 years in Florida with special accrual rules. So basically, it starts accruing from the time of actual possession of the owner, the date of issuance of a certificate of occupancy, the date of abandonment of construction if it's not completed, or the date of completion of the project, whichever is latest. So it's a long dang time. Now, Florida has a special discovery doctrine for construction. Florida has only 2 discovery doctrines. One is for fraud claims and one is for construction. Congratulations, right? None of the other stuff. If you didn't discover the problem and you blew the statute of limitations, you are out of luck. Well, that's not the case in Florida. So the discovery doctrine is this statute of repose, which is 10 years. It's really a very long time. As I mentioned, serving the 558 tolls the accrual of statute of limitations. It does not toll the running of the statute of repose. So that's important, but it is a very, very long time. So there are some other things that do toll, like bankruptcy and even condominium turnover. So if the developer is still in control of the development, condominium or homeowners, and has not technically turned it over to the residents yet, then none of these times actually start running yet. So imagine large-scale developments, you could have liability even beyond the 10 years in that sense from the date you actually did the work. Pre-suit contractual dispute resolution mechanisms like mediation or non-binding arbitration don't toll the running of the statute of limitations or the statute of repose. So this statute of repose, what is it and when does it apply? It applies only to latent defects, not to patent defects. The Florida courts have indicated that a patent defect is one that is obvious. You can see it with the naked eye. You do not have to be an expert. Importantly, you don't even have to know who is responsible or what exactly is causing the problem. An early example of that developed by the courts was roof leaks, right? If you've got water coming through the roof, you've got water coming in through the walls. You may not know exactly where the leak is or what caused it, but you know there's a problem. When you know there's a problem, that's patent and the statute starts accruing. Now, some years later, the court said, well, there are certain roof leaks that are latent. So it's highly fact specific, but essentially latent is something that can't be discovered by the naked eye. It might be in fits and starts. So you see a little whiff of an issue and then it goes away and then it comes back again, maybe in a different manifestation. That could very well be latent. It has to be easily observable. And the fact that it might be easily identified by a qualified expert does not turn something that's patent into latent. Sort of the standard bearer there is it's judged by what would the lay person observe, not what would an expert or a contractor know. There is, however, no bright line test. So it is very, very fact specific. Pending legislation. Okay. So we've got a number of bills. We're in legislative session now that relate to these topics. So the first I'm going to cover is 558 and the statute of limitations. So first thing this does is it attempts to create new statute of repose rules. We have tried through various trade groups and various bills over the last 6 or 7 years to completely eliminate the 10-year statute of repose and have no discovery doctrine, 4 years only. That seems fair. The problem has been the different lobbying groups, they don't all see eye to eye. And it's interesting because we handle commercial, residential, industrial, and road construction here, among other things. They all have their different trade groups and lobbyists. And then there's the insurance side of things. So the insurance lobby wants this, and the various trade groups don't all necessarily agree. So that's been challenging. But this bill creates different repose periods. So electrical, plumbing, mechanical, those things are probably going to fall under the 5-year if we get our way here, as opposed to the 7 or 10. So they only get an extra year beyond the 4. It also puts a deadline for counterclaims, cross claims, and third-party complaints. So one of the big deals here is you file an action for construction defects right now, and it's latent. And you file it right on the eve of the 10-year statute of repose, and it's timely, right? And you're the contractor, the general contractor, the prime contractor that got sued, and you say, wait a minute, it's my subcontractor's fault. It's my plumber's fault. You can't, it's too late to bring in the subcontractor. Under certain rules, under other rules, you can bring the subcontractor in after the 10 years. So it's like, geez, when does this stuff ever end? So here they're trying to create, via this legislation, a 1-year deadline to bring in others. Okay, what does it do to 558? So as I mentioned, 558 doesn't have a ton of teeth. One of the things that isn't great in 558 is the contractor technically is only entitled to propose a resolution. So the contractor says, I will fix everything you want to be fixed in exactly the manner you want it fixed. And the owner says, no. Really, it's the owner's attorney saying no, because that settles the case and they don't get their fee. That is the truth of the matter. So we've been trying in various ways to create some penalty, essentially against the lawyers indirectly, to disincentivize those kinds of things. So here, the premise this year is if you don't accept the proposed cure, then the lawyer doesn't get attorney's fees. They're going to love that. I'm not sure that portion of it's going to pass, quite frankly. The next, I don't love this one at all, is the court is now required to appoint an expert, presumably to assist the court in some fashion. With what, I don't know, because the parties are going to have an expert. There's no mechanism. In years past, the concept was an expert was appointed by the court, did a preliminary assessment, made a finding, And if the parties didn't accept what the expert said, then there were penalties for that. That was watered down out of this year's legislation. So I think this is just an extra cost that the parties would bear. That's really just unfortunate and not helpful. This is an interesting one. So very commonly, a property owner would accept a monetary settlement and then pocket the money and not tell the property owner's insurance carrier, i.e. these were bogus fraudulent claims, especially on single family or condominium projects. The attorney's fees were the tail that wagged the dog and made these feasible for plaintiffs' lawyers. And so, again, prior year's legislation, we said, well, you've got to put the insurance carrier for the owner on notice that there's a claim, that there's a defect. You've got to disclose it to a subsequent buyer of real property. None of those things made it through final legislation to amend 558. This year, we're going in narrow and saying you got to use the money, and if you don't, you're strictly liable to a subsequent owner of that property. So that's a big deal, assuming property owners know about it, which residential likely not, commercial maybe, if they're advised by counsel. Okay, another bill that this affects HVAC contractors directly, if it passes, which I think it will, and it basically increases an exception. So presently, if an HVAC job is $7,500 or under, the HVAC contractor is not required to record a notice of commencement. They're increasing that exception to $15,000, but ignore it, right? Because remember, I told you earlier, liens relate back to the notice of commencement, so you want one recorded anyway. Speaking of liens, there's a ton of stuff being changed or proposed to be changed in the lien law this year, but I've kind of cherry picked what I think would be most relevant here. So remember, I mentioned specially fabricated materials. There's a special rule for calculating when the first furnishing is for serving notice to owner. Well, there's also a special rule or ambiguity in the rule for when someone who is furnishing specially fabricated materials has to record the lien. And so here, basically, what they're trying to do is say, okay, that 90 days doesn't start running until you deliver the last of those specially fabricated materials to the site, instead of maybe when you delivered the first of the materials or half of the materials, or things that lawyers have historically argued over. Interest, as I mentioned, cannot be presently included in liens. This statute proposes to allow interest in the lien. Interestingly, in a lawsuit to foreclose a lien, you are entitled to interest. You just can't include it in the lien, just like you can't include attorney's fees or administrative process costs. You also can't include, by the way, overhead or profit in a lien. So if that's all you're leaning for, you can't lien. Mobile homes, again, this is probably a small portion of any business, I would imagine. Some of your companies do, but there's a special rule I thought I would mention. Presently, you can lien a mobile home for work done on the mobile home. They're changing that so that if it's a rented home, which is pretty common here in Florida, in a park, you can't actually lien the home. All you can lien is the tenant's leasehold interest in the home, which essentially is nothing. You're liening an obligation to pay rent effectively, so that doesn't really help too much in that instance. There's a similar rule when you do work for a tenant, say of commercial property, where you're doing a tenant improvement or build out or service work there that may be lienable. In those instances, it is worth liening the leasehold interest, because a commercial tenant does not want to lose their right to lease the property where they're conducting business. The notice of commencement form may be changing. So we just need to be careful to use the correct notice of commencement form. It's not a very significant change, but it is a change. And rather than ending up in an argument over whether it's a proper notice of commencement, we just have to use the correct form. So kind of to wrap things up here and open it up to any questions, I'm trying to stay within our allotted hour of time. I just kind of thought I'd highlight some of the takeaways. So it is really technical. I've covered like 1% of the surface. We could spend a half a day or longer just on perfecting lien rights. There's a lot of risk when you're doing collection on consumer debts. So just be mindful. Residents, there is risk there in Florida under the FCCPA. Construction defect claims do have a long fuse. You can't alter that fuse via contract, but there are tricks and things to look out for from a defensive standpoint. And, you know, one of the things, Chris, you and I talked briefly about, I think in our first conversation, was sadly, the insurance carriers, you know, the generally approved panel counsel, they're not construction experts. They handle the gamut, including slip and falls and auto accidents and all that stuff. And that's all fine. There's a place for that. But this stuff is highly technical, and they don't know the defenses to raise. They don't know to look for these, you know, it tolls the statute of limitations, but not repos, and, you know, all of these other little niceties and exceptions to the exceptions. And we find a lot of our clients will ask us to stay in the background if we're not representing the carrier, educating the dang lawyer who's supposed to be primarily defending them. And that's it. That's unfortunate. It's one of the reasons after some years we finally decided we're going to do some insurance defense work if the carriers allow. The profit margins are terrible, absolutely atrocious. But, you know, we want to help, and it's good. You can get in front of the clients to do other things for them too at regular hourly rates. So as I mentioned, we just got approved this year to serve as panel counsel for Builders Insurance Group, one of the big national outfits, and would love the opportunity to get in front of, you know, Bayonet or any of the other carriers to show them what we can do and see if we can't get approved. But 558, there are definitely opportunities for resolution there, even with the attorneys just trying to get fees, if you know what you're doing and you don't wait for the carrier to get in the mix. So these are just, again, broad overview of some of the unique issues in Florida. Questions, comments, concerns, other things you'd like to know about?
Well, it sounds like Bayonet has used you for many years. They're very happy with your representation. And now we're opening a Florida division there in Jacksonville. And we will be doing electrical work on homes, new construction, single family. And sometimes we do an apartment project here and there in Florida. We may be doing more now that we're going to have a shop there. So it sounds like we'll be doing pretty much the same sort of work with you that Bruce had already been doing. So I'm looking forward to that and to doing it properly, and to protecting IES and Bayonet and whoever else we acquire in Florida. Is it Edmond? Yeah, Edmondson is also in Florida, aren't they?
Yep.
Yeah. So
Okay.
yeah, we have now 3 places in Florida. So we really have to have a good, strong counsel we can rely on. And I really like it when we can build that bridge between the shop or the division and you, so that I can say, Justin, give Bruce a call, or Justin, you know, give Thomas a call, or Thomas call Justin. And it just makes it so much easier if you can relate to our people and what they do every day. And it sounds like you already do that with Bayonet. So I'm looking forward to working with you.
Yeah, they're good folks. We actually had one of their executives there, Brown, who is, I think, the head of their HR department. Her husband, we had an arrangement with him to come in on a temporary basis for 3 years here and help us as part of our growth. So we have a lot of connections. And Bayonet, for many years, was a huge supporter of our foundation. And I say was only because our signature fundraiser annually was a sporting clay shoot. And we decided we wanted to do something a little different. So they hadn't, you know, we hadn't held that in, I think, 3 years now, but they would bring, I think, 100, 150 people to that shoot. Wow. Every year. So yeah, it was a good deal. Great for company morale and customers and all of that, and good
Yeah,
for
really good.
the veterans that we serve through the foundation. So
Yeah, our guys like that kind of stuff too. They
Yeah.
like to hunt and fish and shoot. Some of the women too.
yes,
Crystal pointed out to me that it looks like you're also licensed in Texas. So do you do lien work in Texas as well?
I don't do much work in Texas, candidly. I obviously I'm licensed in Texas. We do some things in Texas, and a lot of our contractors, being of a larger size, they may have a footprint in Florida, but they're doing work in other states and even internationally. And so we will do a lot of those things and assist them in those territories within the confines of what multi-jurisdictional practice rules allow and such. But yeah, we can do
Yeah.
things in Texas, but we don't do them every day.
Well, thank you for your presentation today. It was really, really interesting.
Justin,
Sure,
I
well-
have one question for you that's completely unrelated to anything that we talked about today.
Awesome. Shoot.
I noticed at the very top center of your PowerPoint, you use World Docs, and we are in the process of transitioning over to World Docs. And I wanted to know your overall review, unbiased, unpaid for, as to whether you like it or not.
Well, first of all, good eyes, because that's a very small icon to see, but we love it. We have had it since 2009. Our firm went paperless in 2010. That's it. There's paper around, but we are essentially paperless. It is extraordinarily customizable, very fast, easily searchable. We absolutely love it. It is the backbone of what we do here.
Cool.
I highly recommend it.
Good.
Awesome. Good to know. I was just curious. Thank you.
You bet. You bet. Well, I'm sorry I couldn't have made it a little more interesting and more interactive. If we had a little more time, I certainly would have done that and weaved in some war stories and a little interaction, which is what I like to do. But I appreciate even an hour of your time and be able to talk with you a little bit more and get to know you and you me a little bit. So.
Great. Thank you, Justin. We appreciate it.
You bet. Have a great day.
Thanks, Justin.
See ya.
All right. Bye.
I could work with that.